Good morning, everybody. I'm very pleased to welcome you here today to this special session of the California Supreme Court. I would first like to introduce my colleagues on the bench in order of seniority. To my immediate right is Justice Carol Corrigan. To my immediate left is Justice Goodwin Liu. To my further right is Justice Leandra Kruger. To my further left is Justice Joshua Groban. And then on the far right, we have Justice Barton Jenkins. On the far left, we have Justice Kelly Evans, our newest justice. 7 years ago, in 2016, the California Supreme Court accepted an invitation from Administrative Presiding Justice Judith McConnell and the other justices and staff on the 4th District Court of Appeal, Division 1. At that time, the California Supreme Court held a special oral argument session, and it was in place of one of the ones that we traditionally have in different locations, usually in San Francisco, Los Angeles, and Sacramento. Under our two former Chief Justices of California, Chief Justice Tani Cantil-Sakaue and Chief Justice Ronald George, members of this court have held special oral argument sessions in different locations around the state, often arranging for high school students to observe oral argument and ask questions of the justices. So we are pleased to continue that tradition here today, and the court thanks Justice McConnell for inviting us back to participate in this important public outreach effort. Our purpose is to bring the court to the community and to encourage civics education about the courts, the judicial system, and the administration of justice. We also extend special thanks to all the other justices on the 4th District Court of Appeal who met with the students and the attorneys who did the same to review the very lengthy briefs and to educate the students regarding the role of the California Supreme Court and the importance of an independent and impartial judicial branch. This year, we're pleased to have students from 3 schools and 2 after-school programs: King-Chavez High School, Monarch School, Crawford High School, Reality Changers, and Barrio Logan College Institute. We thank these schools and the organizations, the principals, the teachers, and the students for all your helpful assistance. And we look forward to hearing questions from the students later today following oral argument. At this time, I would like to turn it over for some remarks from Justice McConnell.
Thank you very much, Chief, and welcome to our court. All of you, we're so honored to have you here in our court, which was designed to accommodate you, and we hope that you will come back many times. I think educating our youth about the value of our fair and impartial judiciary is critical, and would like to introduce some of the justices who helped orient the students. And just to let you know, one school, Crawford Academy, will be coming in after argument on the first case because they had transportation challenges. So I'll start with Justice Castillo, who went to King-Chavez High with Karen Harkin, who is somewhere in the back. Justice Julia Kellety, who went to Monarch School with Leslie Gallagher, who's also somewhere back there. Justice Doe is not here this morning. She was not feeling well, but I think Chelsea Mutual is here, and they went to Crawford High. Justice Buchanan and Vivian Sapthavi went to Reality Changers, and Justice Buchanan did double duty by also going with Chelsea Mutual to Barrio Logan College Institute, and I thank all of them. Justice Dado, I didn't introduce you. Justice Dado is one of our distinguished colleagues, and he has also been very engaged in community outreach. But thank you very much for being here, and I will turn the microphone back to you, and we are going to gracefully exit the well.
Thank you so much. Thank you to all of you for your assistance. The clerk may call the calendar, please.
Good morning. The Supreme Court of California hearing arguments in San Diego on June 6, 2023 at 9 a.m. Case number S27-33910 Camacho, petitioner versus Superior Court of Merced County, respondent, the people, real party interest. This matter is continued to the June 27 calendar. Case number S269237, the people, plaintiff and respondent versus Dontre Gray, defendant and appellant. For appellant, Mr. William J. Capriola. Ready. And for respondent, Ms. Teresa A. Reed Depot. Ready. Case number S272237, the people, plaintiff and respondent versus Jason Carl Schuler, defendant and appellant. For appellant, Mr. David L. Polsky. Ready. And for respondent, Ms. Jennifer M. Poe.
Ready. Thank you. Calling the first matter, the people versus Dontre Gray. Mr. Capriola, whenever you're ready. And once you're set up, if you could let me know how much time you would like to reserve.
10 minutes.
Thank you.
Good morning, Your Honors. May it please the court, William Capriola for Mr. Gray. In Morrissey versus Brewer, our United States Supreme Court said that the minimum requirements of due process requires, in a probation or parole revocation hearing, the right to confront and cross-examine an adverse witness, unless the judicial officer at that hearing finds good cause for that not to occur. Imagine the facts of this case, and where we have a hearsay declarant who recanted after making the statements on the body camera video. And imagine that the prosecution was fully satisfied with that body camera and thought, I can obtain a ruling on at the revocation hearing. I'm not going to bother to call her at the hearing. She'd be very easy to and amenable to testify. But I'm not going to bother because I have this and I don't need her going sideways on me. Under the Attorney General's position in the opinion of the Court of Appeal below, that would be perfectly acceptable because we'd have a per se rule that that whenever you have as long as the statement fit within a firmly established hearsay exception, like the spontaneous statement exception, then that would be, you could admit that statement and you wouldn't, nobody would be any the wiser that this person wasn't called, and assuming that defense didn't have access to her for some reason and didn't call her, or maybe you didn't even know where she was, that would be all right. Now the Attorney General's position is that a firmly rooted hearsay exception is per se admissible because it is has the indicia of reliability.
Why isn't that sufficient? Isn't that what we're really trying to get to when we determine whether evidence should be admitted? I think your answer will be no. But also, if you could address the argument that there's some incongruity between the tests that you're asking us to adopt and the result, which the argument is that you're allowing evidence to come in a probation revocation hearing in a way that's easier than in a criminal trial. If you could address that.
Yes, I don't believe it is easier to come in, and I don't believe that's dispositive either. There are many differences between revocation hearings and a criminal trial. At a revocation hearing, there's no right to a jury trial. The standard is proof beyond a reasonable doubt rather than a preponderance of the evidence. The rules of evidence do not strictly apply or really apply much at all.
But counsel, focusing in on the confrontation, the right to confrontation specifically, following up on the Chief Justice's question, isn't the test that you're proposing or the rule you're proposing, wouldn't it in fact give individuals in these hearings greater confrontation rights than apply in a criminal trial?
No, not necessarily. Maybe, I imagine that there could be a specific case where maybe evidence might be admissible at a revocation hearing that might not be admissible.
Why is the answer no, not necessarily?
Well, because it comes down to the facts of any particular case. If we're talking about under Crawford at a criminal trial, if we're talking about
Yes,
testimonial
but
evidence.
the rule that you argue for would impose a good cause requirement, right?
Yes.
That is not necessary in a trial, a full-blown criminal trial. So my colleague's question seemed to be to suggest on good authority that the admissibility of this evidence would be more onerous under the standard you propose than it would be for a criminal adult trial.
It's true. The good cause requirement doesn't apply in a criminal trial. However, the confrontation clause per se doesn't apply at a revocation hearing. So we're kind of comparing two different things here.
So is the position you're espousing one that would likewise distinguish between testimonial and non-testimonial statements along the lines that the confrontation clause after Crawford instructs us to
Yes,
do?
I think that would be a factor that would be considered when looking at good cause and whether or not, and when you're doing the balancing, whether or not this was testimonial evidence or non-testimonial.
Now, how would that question relate to the question whether or not there's good cause for failing to produce the actual witness to testify?
Well, if it was, if the statement was testimonial, then you would have to, it would affect the good cause. The good cause standing would go up and down depending on whether or not the statement was testimonial or not.
Now, this notion of what's testimonial comes to us from Crawford.
Yes,
It's based in the Sixth Amendment in the Crawford analysis.
yes.
Why should that testimonial test apply in the context of a revocation hearing that is where the rights are based on due process?
Because we're talking about the it's just not the due process clause, it's the due process right of confrontation and cross-examination.
Well, Crawford squarely based its ruling on the Sixth Amendment, not on a due process analysis. Didn't say due process wasn't important,
Yes.
but it is very clear that the beginning and end of the rules in Crawford stem from the Sixth Amendment. So how do we make that transition to Morrissey hearings and under a different constitutional analysis?
I believe you always have to look at the Sixth Amendment case law to inform the analysis under the at a revocation hearing, because we are talking about the right to confront and cross-examine witnesses. Now, it's not exactly the same, but that jurisprudence is certainly relevant to the determination of whether or not that evidence is admissible or not.
But we do know that there are some significant differences between the due process analysis, which brings with it the good cause aspect of the analysis,
Yes.
and the very strict Sixth Amendment, you have to do it this way or you're done analysis. So how do we make that leap?
How do you make the, well, assuming, for instance, just going back to Your Honor's question, if the testimony was testimonial or not, it could be admitted at a revocation hearing without the witness being present or without an opportunity for prior cross-examination. That would not be admissible at a criminal trial. I believe that the two, throughout the history of the right to due process right of confrontation at a revocation hearing, I believe that case law has always looked to Sixth Amendment cases to inform that inquiry.
What about non-testimonial statements? What is the proper analysis for a statement? Say it's a statement that came in under the spontaneous statements exception, and so whether or not the witness is available to testify at trial is irrelevant for purposes of
if it was a
introducing that statement.
non-testimonial statement, and once again, it doesn't have to be an exact Crawford analysis here, but if it was a non-testimonial statement, then the defendant's right to confront the witness would be less in those
How
circumstances.
much of the Crawford analysis do we import? Is that what you're suggesting into the due process analysis, where there is a right to confront the witness?
I think it's one factor to be considered, just like reliability is one factor to be considered, because our Supreme Court has said.
But Crawford sets up an absolute standard, correct?
Crawford sets up an absolute standard.
So, back to my question, I'm not sure where we draw the line of how much we import.
I think it's just that whether or not the statement is testimonial or not, even Areola says that testimonial statements should be, the court should be very careful in viewing that, because it's basically a substitute for live testimony here. And so I think it's a factor, along with whether or not there was good cause for not having the hearsay declarant present at the hearing, and whether or not this evidence is important to the revocation hearing itself.
Is there an agreement here on what we're dealing with for this particular case as to whether it's testimonial or non-testimonial?
I believe that the trial judge had found that it was testimonial and therefore would not be admissible at a criminal trial, which is why the district attorney dropped the criminal charges against my client and decided to proceed only under only on the probation revocation.
Then do we have to address the standard that we apply for non-testimonial statements?
I believe that a test should be created that covers whether testimonial or non-testimonial statements, yes. Whether or not you have to do it, I don't believe you have to, because it's not within necessarily the facts of this case, since at this point it's not in dispute whether or not the statement was testimonial or not. But
Counsel, I just want to make sure I understand. I thought a moment ago you were saying that you were proposing to draw a line to distinguish testimonial versus non-testimonial, but just a moment ago in response to the Chief Justice, I thought you said you would recommend that whatever test we come up with cover both.
yes,
So which is it? Okay.
I would prefer. I think it would be best to come up with a test that covers all.
The same test.
Yeah, the same test.
The
One that would cover everything.
The potential inconsistency between a criminal proceeding and a revocation hearing, I hear you to be recognizing, really becomes clear in the non-testimonial context, right? Because,
Yes.
And how do you reconcile that, or what should we do about that? That for a non-testimonial piece of evidence, it's coming in a criminal trial and may not come in a revocation proceeding, which your friend on the other side says is
No,
backwards.
it doesn't necessarily come in a criminal trial. I mean, under a 352 analysis, it might be excluded, even if it did satisfy.
Right, but your friend on the other side says, but defendant is better off in the revocation hearing than in the criminal context, and that doesn't make sense.
Mm-hmm.
What of that?
Could you repeat that?
Yeah, your friend says, yeah, it might not come in, but the defendant is still going to have more rights in the revocation process than they are in a criminal trial vis-a-vis non-testimonial evidence,
Yes.
and that's backwards, they say.
Yes. Now, I don't think it's necessarily true to say you'd have more rights, because this is just one piece of evidence. This is not. I mean, you need to look at the whole picture here, and just because you're getting in one piece of evidence doesn't mean that you have more rights at the revocation hearing. And in a revocation hearing, typically there's a lot less evidence introduced, and maybe more times than not, this one piece of evidence in a case such as this is going to be the defining piece of evidence in the case.
But you just said, and I want to think about this a little bit, but you just said that in the non-testimonial context, the evidence doesn't necessarily come in at a trial. Mm-hmm. And then you rely on 352 of the evidence code. But it seems to me if you have a spontaneous statement that's offered for admission in a trial, and it fits within the spontaneous statement exception to the hearsay rule,
Mm-hmm.
I don't think many judges are going to exclude that under 352.
That might be true, but But if it was a case such as this one, and all of the evidence in the case basically was this one statement, the body camera, the hearsay declarant statements on the officer's body cam, and there were other indications that she had recanted, maybe the prejudice is too great without having her present at the hearing, and it might be excluded under 352. I mean, I can imagine situations where it would be. I agree that it'd probably be unlikely to be excluded, but there are situations where it could arise where the prejudice would be too great to admit that evidence.
Now, when you say prejudice under 352, ordinarily we think of prejudicial evidence because it's so hair-raisingly emotionally fraught that the trier of fact won't pay attention and rationally evaluate the question. They'll decide it on emotion. I'm having a tough time coming up with an example of where that would be the case when there's no jury. It's supposedly a dispassionate judge making the determination, and it's usually the kinds of evidence we're talking about in a probation revocation hearing are usually pretty focused. They aren't far afield and things of that nature. So I'm having a tough time figuring out how you're suggesting the concept of prejudice is going to happen in a probation revocation hearing.
Well, I was addressing Justice Jenkins' question with regard to admitting that evidence at a criminal trial where evidence code 352 would definitely apply. It doesn't necessarily apply, at least not as strongly at a revocation hearing, but at a revocation hearing, a different analysis applies. And that would be whether or not that statement should come in would be balanced against the importance of that evidence, whether or not the declarant, the prosecution can show some kind of good cause for the declarant not being there or not.
Okay, but that's really not a 352 analysis.
No, it's not
That's a due process analysis.
It's not a 352. They're not an identical analysis.
Thank you.
Can I ask for a little bit more clarity on how you're suggesting we think about the good cause requirement in these circumstances? So this is a situation, it's not an uncommon situation, in which, say, a judge finds that an out-of-court statement is inherently reliable, but the witness, not because of any external impediment to coming into court, not because of sort of a credible threat of harm, but because of other reasons, the witness is non-cooperative, right?
Yes.
How do you suggest that we think about good cause under those circumstances?
I think you think about good cause the way that your honors have discussed it in both Areola and Winson, which is the traditional kind of like a unavailability plus analysis. It's not just pure unavailability under the evidence code, but there are more. It's a broader scope, not just whether or not the witness was legally unavailable, but also whether or not it'd be extremely difficult, whether or not it might be dangerous for that witness to testify at the hearing, whether or not the prosecution has made efforts.
What about a situation in which the witness is reluctant to testify against a loved one?
Yes, I believe that's a situation that you consider as well, but I think that the defendant's right to confront that person, that loved one, would outweigh
but I guess the
mere
question
reluctance.
is, do we get past the initial good cause threshold to the balancing of the need for confrontation versus the sort of countervailing interests at stake, or?
I don't know if you need to actually stop at the good cause. I think good cause should be looked. I know the language in Areola is first you look at good cause, then you look to see what the balancing of interests. I believe that you should look at good cause or lack thereof of good cause and a balancing of interests. In Maki, for instance, with documentary evidence, there was no finding of unavailability and of the documentary evidence of the people who wrote the documents. And, but I still think that given other circumstances in that case, if you wanted to try to harmonize that case with the Areola-Winston analysis, that other factors such as we are just talking about documentary evidence here and whether or not these invoices are accurate and that's the defendant's signature or not, then that would be factors to consider in the analysis. So good cause and the importance of the evidence, whether or not there is any corroborating evidence to go along with it, whether or not this is the only evidence at the revocation hearing or not.
In other words, it's not a two-step test that you're asking us to adopt. It's a sort of analysis of all the circumstances and
Yes.
balancing.
Yes.
So it's really just defaults to balancing.
Yes, default to balancing, exactly. And I think that's unclear from Areola, and Winston and even Maki, what the analysis is, but I would advocate in favor of just a general case by case, because I believe that's the most consistent with the due process clause. It needs to be flexible. You need to look at all the circumstances here. We're not talking just about the reliability of the particular evidence itself. We're talking about the reliability of the final determination of whether or not to revoke probation or parole. And just because one piece of evidence might be reliable within the meaning of the law doesn't mean that the final decision on whether or not to revoke probation is going to be reliable.
Okay, thank you, Mr. Capriola. You're at your requested time. You'll
Thank
have
you.
4 minutes left for rebuttal.
Thank you.
We'll now hear from Ms., is it Dippo or Depot? Dippo, Ms. Dippo, thank you.
Good morning, Your Honors, and may it please the Court. It is undisputed that the victim's statements captured by body camera qualify for the spontaneous statement exception to the hearsay bar, codified in Section 1240 of the Evidence Code. That exception fits within a broad and long-standing recognition in our legal system that spontaneous statements are particularly reliable and bring evidentiary value that cannot be recaptured through in-court testimony.
Isn't there a little challenge in this case? Because we do generally assume, for purposes of the exception, that spontaneous utterances are inherently reliable. But in this case, we have a declarant who later says, no, this is not reliable. I was lying, and I thought about lying for this reason. So that kind of undercuts the whole basis for the whole reliability thing, doesn't it?
I don't think it undercuts the trial court's determination that the statements originally made on the body camera fall within the spontaneous statement exception.
Okay, that's a nice lawyer-like answer, and it's true. But then do we just say, whoop, we check off all the boxes for the exception, and so it's coming in, even though the declarant who made the statement says, nah, I was lying?
I do think it sort of underscores why the spontaneous statement exception exists and why our legislature has adopted it, that the statements made at the time might be a particular reaction without time to reflect or fabricate later. And certainly it's not unusual for a victim of domestic violence to express one set of accounts about what happened close in time to the event and then later express reluctance about bringing that account into a formal in-court proceeding. But I would also say, the evidence of the recantation here was considered by the trial court, and it was absolutely relevant to the question whether the prosecution carried its burden to show a violation of probation by a preponderance of the evidence. And so the question in this case isn't about limiting the scope of what the trial court can consider or limiting the ability of the prosecution or the defense to call the declarant to testify. It's simply about whether the spontaneous statements themselves are sufficiently reliable that they should be admitted, consistent with the due process interests that govern here. And
It's the consistent with the due process interests that govern here that I'm not sure you fully accounted for in that answer. In my colleague's hypothetical, there is an issue with respect to whether the statements that were made closer in time are indeed reliable. And we know from the case law from the Supreme Court that one of the things that the Due Process Clause focuses on is the right to confrontation. How is that interest at all accounted for in your argument here?
So I think there's two things there. First, as to the judgment of reliability of these statements, I do think that's baked into the determination by the trial court that they fall within the exception, and the longstanding recognition of the legislature and judiciary that statements made at the time under the stress of excitement of a contemporaneous event do have special evidentiary value, notwithstanding that there might be other evidence that corroborates or fails to corroborate those spontaneous statements.
On a continuum, is there a range at which trial judges admit evidence as spontaneous statements? You could have one where the declarant is under the aegis of whatever the startling event is and makes a statement. And then you could have a scenario like this where there's an interview that goes on for a period of time.
I think there are factors that can affect whether statements made at the time are spontaneous.
But your argument is that once admitted, end of story, per se reliable.
I think once the judgment is made that the statements do fall within the spontaneous statement exception, they pass muster under the due process analysis here. But I will say the statements here are an example. The determination made by the trial court here exemplifies the sort of factors that a trial court should look at before deciding whether the statements qualify for the spontaneous statement exception. So here the trial court looked at the statements and it said she's clearly still reeling from the event when she makes these statements. She has to leave to splash water on her face. Her face is shaking as she's recounting what just happened. And this is all happening very close in time to the incident. I think the record reflects that the police showed up 4 minutes after she called 911 during the incident.
So, counsel, I think that's just the ordinary inquiry, right, for application of this particular hearsay exception. And I think the questions from the bench, I think, concern an added layer and whether that added layer is necessary. I guess I'll focus your attention on the notion that these statements here are testimonial. Do you take issue with that?
We didn't dispute that.
Okay, so what does that add to this analysis, if anything?
So I think the fact that these statements are testimonial is sort of the gateway to the question that is addressed in the briefs and that is presented in this case.
That's why we're here.
Yes. That if the evidence here were non-testimonial evidence falling within a hearsay exception that would have been admissible at a criminal trial, it should likewise be admissible at a revocation hearing with no additional analysis.
But what if the argument that in a criminal trial that the judge would be asking an additional layer of questions under 352? Is there a sort of parallel avenue for the court to consider those kinds of sort of case-specific factors in the context of a revocation hearing?
I think it's conceivable that perhaps non-testimonial statements falling within a hearsay exception maybe could be objected to on a due process basis in an individual criminal case. And so if there were a due process basis for objecting to them, that could come up again and perhaps inform the analysis at the revocation hearing. But in general, non-testimonial evidence that's admissible under a hearsay exception should come in likewise at a revocation proceeding, because there are due process interests at a criminal trial too, but surely they're heightened relative to a revocation hearing where, as the United States Supreme Court has talked about, the probationer or parolee has only a conditional liberty interest. The state's interest in returning the individual to custody is stronger in light of the prior conviction and the conditions.
I guess I haven't followed your answer to its ultimate conclusion yet. So you talked about non-testimonial hearsay exception statements, but that's not really what's at issue here. So for the testimonial statements, what is the argument?
So for testimonial statements falling within a hearsay exception, I think it depends. That's how we get to the question of, are we doing the areola, good cause and balancing analysis, or are we doing, as we advocate for spontaneous statements here, a bright line rule? For spontaneous statements, we would say that the bright line rule is appropriate because of the legal system's recognition of the reliability and value of that evidence. But in other circumstances, areola's test might make sense.
And what is the argument for not having the same, I mean, a minute ago you were urging a parallelism between the treatment of non-testimonial statements as between a criminal trial and the revocation hearing, why wouldn't the same parallelism obtain for testimonial statements?
I think it's because there are due process rights at a criminal trial, as I suggested, but at a criminal trial, they're primarily protected by the Sixth Amendment. So even though the Sixth Amendment is certainly a different test and it derives from the original meaning of the Confrontation Clause, when the Sixth Amendment would bar admission of hearsay evidence at a criminal trial, it's appropriate to do some further due process consideration in the revocation context. And for spontaneous statements, they would pass muster because of the inherent reliability that we've described in our brief. But for other types of statements, additional.
Why is that, though? I mean, so I guess your answer is that the due process consideration is baked into the legislature's enunciation of the spontaneous statement hearsay exception. Is that what you're saying, essentially?
It's primarily that. It's
That is what a categorical rule implies, though. If you acknowledge that there are due process interests, and yet you say it's a categorical rule, then I guess when you add those two things together, it means, or it must mean, that the due process is accounted for.
I think that's right. It also derives from the nature of the particular exception here because it is so long-standing and so widely recognized.
So I guess the further question then, if you are willing to go that far, is why would we truncate the due process inquiry in this way? I mean, that would be somewhat anomalous because normally we think of the due process notion as probably one of the most flexible conceptions in the law. We don't generally have categorical rules that simply, say it's just these factors here that we're looking at and not all the circumstances. So why would that be?
I think there are a few reasons. One goes to some of the earlier questions of your colleagues about the nature of the good cause prong of the Areola standard. So if you accept Areola's two-part test as the alternative, that good cause standard is pretty concrete and it does require declarant unavailability or a similar showing. And it's not flexible. It doesn't take into account the reliability of the evidence as a means to overcome that good cause requirement. And so this case illustrates that point because the Court of Appeal concluded that the good cause requirement wasn't satisfied, even though there were efforts undertaken below to get the declarant into court to testify. And although we would dispute the Court of Appeal's determination on good cause in this case, it illustrates that if the Court of Appeal hadn't applied a bright line rule, it would have excluded this evidence from consideration.
But you're making the assumption that it's sort of the two-part test should be applied in that manner versus I guess it's an open question as to whether that's the correct analysis versus a more general balancing of interest where good cause is taken into consideration. The defendant's interest in confronting the witnesses against him or her is taken into consideration, and the prosecution's interests are taken into consideration. Why isn't that the proper analysis, and why isn't reliability of a spontaneous statement just one factor, not a dispositive one in the analysis?
Your Honor, if the court isn't comfortable with a bright line rule, I think the two elements that you just highlighted would be critical to an opinion adopting a different balancing test. So the first is that the good cause standard of Areola isn't appropriate in this circumstance, in part because of its concreteness and its inability to give way to the reliability of evidence, but also in particular as to spontaneous statements, which have traditionally been admissible without any showing of declarant unavailability, both under the evidence code and also under the prior reliability-based approach to the Confrontation Clause described in Ohio against Roberts and White against Illinois. And then the second point is that a balancing test would recognize that the reliability of evidence that falls within an established hearsay exception, here spontaneous statements, is a heavy thumb on the scale in favor of admitting that evidence. And that is similar to what the Oregon Supreme Court recently said in the State against Martin decision, where it declined to adopt a bright line rule, but caveated the significance of reliability in any balancing analysis.
The first thing you said, though, is that the good cause requirement of Areola isn't appropriate, is that, explain that if that's your position, or is your position really, oh, you'll do good cause under areola, but you do it as part of, you smush the two steps together. It's not unavailability first and then to the second, which ironically seems to be essentially the position that your friend on the other side was taking as well. So I want to make sure that the two parties aren't actually in full-throated agreement rather than disagreement.
To be clear, we think a bright line rule is appropriate because spontaneous statement evidence satisfies the reliability interest here. But if the court disagrees, as I was describing in response to the Chief Justice's question, this would be an approach that the court could articulate in its opinion that I think would be an improvement on the current landscape. So just to go back to the question about whether to get rid of good cause or to smush it together, I tend to think that for spontaneous statements, getting rid of it might make more sense because of what I just alluded to, that for spontaneous statements, there's not been a requirement of a showing of declarant unavailability in other contexts. And so it seems a little bit anomalous to add it in here where the due process interests are supposed to result in somewhat more relaxed procedures. But smushing it would be an improvement on the two-prong.
Right. It's just a tricky. It's a tricky fact pattern, right? Because you're not contesting the trial court's finding that this was testimonial, but you also remind us in the briefing, this isn't like live testimony. This is different. This has special indicia of reliability, but that's an uncomfortable fit with the finding that it's testimonial, because testimonial, right, sort of means, well, the notion is that it's likely to be used in a criminal prosecution, which sounds a lot like a substitute for live testimony. So I wonder if there's some tension there between saying, yes, we don't contest that it's testimonial, but don't worry, this is nothing like live testimony, because it feels a little bit like a substitute for live testimony.
I appreciate the tension that Your Honor is describing. I think candidly that these statements perhaps fall sort of on the line on the testimonial determination that the trial court made, but again, that's the premise of this case, and we didn't dispute it below, and we don't purport to dispute it now. I will point out that this kind of strange marriage of spontaneous statements and testimonial evidence occurred here, but it has also occurred in other cases. So in particular, the Liggins case, which was also the spontaneous statements of a domestic violence victim that were later recanted. Those statements too were found testimonial, but fell within the spontaneous statement exception. So I think it does happen just by virtue of the fact that they are two somewhat different tests, and they're two standards that have been articulated by two different courts in two different ways.
Counsel, you rely so heavily on reliability, and I understand why. I'd like to hear your specific response to the authorities relied on by your friend on the other side that questions the inherent reliability necessarily of spontaneous statements. He cited in his brief a number of studies and also some cases that question that. That's one of them saying that there can be a fight or flight response, and some people, their response may be to say whatever it takes to get them out of the situation, whether or not it's true or concrete. I don't know what happened here. None of us were there, so I don't know what happened here, but I'd like to hear your specific response to those authorities.
We didn't introduce conflicting empirical studies or academic literature in our brief. I think we do rely on the notion that the spontaneous statement exception is baked into our legal tradition. So we don't view it as a judgment that we are making for the first time or independently in this case, or that the court has to make independently or for the first time in this case. The White against Illinois case, which is the United States Supreme Court decision that applied the prior reliability-based interpretation of the Sixth Amendment Confrontation Clause to spontaneous statements, describes in footnote 8 just how long-standing and well-established the tradition of recognition for spontaneous statements is. And so I think that is what should govern the court's analysis, and that's why we haven't disputed the empirical references from my friend on the other side in our brief or here. We just don't think that that's what should carry the court's analysis.
So are you inviting us to say, look at this in two ways? One is what's the rule for admissibility? And even though that may let in some evidence that's a little shaky, because here, for example, the woman who made the statement later says it's not true, we can rely on the role of the judge to sort all that out and say, okay, I'm going to let it in, but I'm also going to look at whether or not it's reliable.
I think that's exactly right. The question here isn't about what the trial court can or can't consider. It's simply about whether this evidence can be admitted consistent with the due process focus on reliability in this context. And this case does illustrate sort of the breadth of the wider consideration that the trial court can undertake, because the trial court did consider evidence of both recantations, and it also considered other aspects of evidence. This wasn't the sole piece of evidence that it based its decision
How can
on.
the trial court judge fully consider the recantation without inquiring of the victim who has recanted?
Allowing the spontaneous statements to come in doesn't keep the prosecution or defense from trying to secure her testimony, but this was a situation where she simply didn't appear, and so the trial court had to consider the evidence.
But
that
that's
was
not
before it.
uncommon. That's not uncommon in some of these types of cases. That's just not uncommon for not only a victim to recant, but not decide not to testify. There are lots of issues going back and forth, emotional issues. It's challenging.
I appreciate that. All of that can be considered by the trial court, but this question is just about whether the
You
spontaneous
consider it
statement.
hypothetically? How do you consider it without access to the victim?
Well, I think it can be considered concretely. I mean, certainly, the trial court didn't have the opportunity to see the declarant be questioned about the recantations, but the inquiry here isn't about reliability as an absolute matter, maximum reliability. It's about reliability under relaxed standards at a revocation hearing. And I think this court's opinions in Areola and Mackey illustrate that point, because even under the Areola standard, there are circumstances where evidence can come in without a witness being called to testify, and that's certainly permitted, and that might be the case even though reliability as an absolute matter might be enhanced by cross-examination of that witness. Similarly, in Mackey, the court permitted certain documentary evidence to come in, even though the credibility and reliability of that evidence might have been enhanced if a custodian had come in and testified about where that evidence had come from. I think it was a car rental invoice about actually seeing the defendant rent the car. That would have enhanced.
That seems much different if you're dealing with documentary evidence, tying and seeing the defendant's signature to the types of evidence indicating there was out-of-town travel. It seems much different than a witness who you're able to see their demeanor and the defendant's opportunity to question that witness. Doesn't it seem much different than documents?
Absolutely, it's different. I just meant to make the point that when we're talking about the reliability standards at a revocation hearing, they're not asking for absolute perfect reliability. They're asking for reliability, and the standard in Morrissey is so that any finding of a violation can be based on accurate information. So it's meant to be flexible and informal in the procedures that it requires. That's why we think that the bright line rule for spontaneous statements is the best approach and satisfies due process. But it doesn't negate the fact that certainly confrontation may have value. It's just not absolute value in this context.
What other types of hearsay would be subject to a similar bright line rule? Would it be any statements that would be admissible in a criminal trial under a hearsay exception for which the witness's availability is irrelevant, or?
That would be one way to craft a rule, and I think that would pull at the features of spontaneous statements that we've emphasized. that they're particularly reliable, that they provide value that can't be recaptured by in-court testimony, and that they have traditionally been admissible without any showing of unavailability. Obviously, we focused our brief here on spontaneous statements, and so I think the court could also issue an opinion in this case that was limited to spontaneous statements, but maybe emphasized those considerations as well.
I guess I'm just, are there sort of concrete examples
Yes.
of other types of statements that would come in under your rule?
Yes, I think dying declarations are a good example. I think co-conspirator statements are a good example. Statements in pursuit of medical treatment, present sense impressions. Those are some that I think are clearer examples. And I do think the United States Supreme Court's prior jurisprudence looking at when hearsay exceptions satisfied indicia of reliability, again, under a prior interpretation of the Confrontation Clause, I do think those cases could be relevant just because they describe and look at the reliability of certain hearsay exceptions, as they did for spontaneous statements in the White case.
But of course, one of the challenges is one of the reasons that the court discussed in Crawford for reconceptualizing how the Confrontation Clause should be interpreted and applied was that under that prior regime, different courts were reaching very different conclusions and undertaking this kind of, sort of very generalized inquiry into what kinds of out-of-court statements are sufficiently reliable to be used against a defendant in a criminal trial.
I think that's right. I do think there are benefits to having certainty, for example, about spontaneous statements in revocation proceedings, because once there is a clear rule, it minimizes the burdens on the trial courts and parties. They don't have to relitigate and re-examine the value of this evidence in every case. But it's true that trial courts would have to look at the sort of factors and characteristics of hearsay exception evidence, potentially, depending on how the court crafts its opinion, to decide if a bright line rule was appropriate for a category of evidence. I'll go back to one thing relating to the questions that were asked of my friend on the other side, which is just this incongruity with criminal proceedings. And just underscore that in response to the Chief Justice's questions a moment ago, I described 2 points that the court could clarify in its opinion if it rejected a bright line rule. And I think the third point is just this notion that non-testimonial evidence that falls within a hearsay exception that would be admissible at a criminal trial consistent with due process there should also be admissible at a revocation hearing without additional analysis, whether under Areola or otherwise. I think that would help to clarify and remove any inconsistency between the criminal context, which has heightened due process relative to the revocation context. I think that's all I wanted to cover, Your Honor.
Okay, thank you very much for your
Thank you.
arguments. Mr. Capriola, you actually have 9 minutes left.
Actually, Your Honors, I don't really have anything else to add unless you have questions.
No further questions, it appears. So we thank you both for your arguments,
Thank you.
and the matter is submitted. Calling our next matter, the People versus Mr. Schuler. Mr. Polsky, whenever you're ready. And also, Mr. Polsky, if you could please tell me how much time you would like to reserve.
I won't be reserving any time.
Okay, so full 30 minutes?
Full 30 minutes.
Okay.
May it please the court, David Polsky on behalf of appellant Jason Schuler. So the issue before the court is whether the failure to instruct on the lesser included offense of voluntary manslaughter based on imperfect self-defense is a violation of the federal constitution requiring application of Chapman, or a violation of state law only requiring application of the standard for prejudice under Watson. But I think there's a more fundamental question that has to be answered in order to answer the question that's before the court. And that is, does the due process clause require the prosecutor to prove the absence of imperfect self-defense where the evidence supports it? Or is that just simply a creation of state law? Winship holds that the prosecutor bears the burden of proving beyond a reasonable doubt. Excuse me. Under the due process clause, every fact necessary to constitute the crime. People versus Floods holds that the failure to instruct the jury on one of those Winship facts or an element of the crime is necessarily a violation of the federal constitution. So by default, if the prosecutor bears the burden of proving the absence of imperfect self-defense under the due process clause, then the failure to instruct on that burden would necessarily be a violation of the federal constitution as well.
And so if we put it in context, we begin with the notion that murder requires the doing of an act that results in death, and doing it with the state of mind that we call malice. And the notion of imperfect self-defense is that it negates malice, right?
Correct.
So even though there may be evidence that a defendant intended to kill, which we would ordinarily understand as malice, the law says we negate that malice because of the evidence of imperfect self-defense. And so if we don't tell the jury about that doctrine, they don't know how to evaluate malice to see if the DA proved it.
That's correct. I mean, that's essentially our position. So what, as the court held in People versus Rios, in order for a jury to find the existence of malice where the issue of imperfect self-defense has been put in issue, where there's at least some evidence of it, in order for the prosecutor to establish there is malice, they are going to have to prove the absence of imperfect self-defense. And one of the things that I found so powerful in the dissent by Justice Kennard in People versus Braverman was not so much her sense of the relationship necessarily between murder and voluntary manslaughter, but she made an argument that we don't often make much, which is a fundamental fairness argument, which is that it's completely unjust to allow the prosecution to obtain a murder conviction based on the jury's ignorance of the role that imperfect self-defense plays with respect to malice. And that's what would happen if the jury is never told that the prosecutor bears the burden.
Okay, well, I guess the alternative view here is that failure to instruct is an error, right? But the defense has put on all the evidence anyway. And the jury is still told that it has to find malice. And in the consideration of all the evidence, there is counter evidence, of course, that negates malice. And the jury is told all of that and weighs all of that in the appropriate consideration of direct and circumstantial evidence as the standard jury instructions would inform the jury. They're to take into account all the factors that may bear on malice. Why is that not enough? For federal constitutional purposes, why is that not enough? Why, I mean, of course it is correct as a matter of state law that there should have been an instruction, but from the standpoint of finding the element, the jury has still heard all the evidence and is told to consider it all.
The jury's heard the evidence and they've been told how to consider it, but they haven't been told how to apply it or what the role of that evidence is in making a determination on malice. What's significant about the way the mental state for murder in California works, which parallels the way it worked in Maine under Mulaney versus Wilbur, which is the mental state for both murder and manslaughter is essentially the same. There either has to be an intent to kill, or there has to be conscious disregard for human life. What the jury is told is that if the prosecutor has proven either one of those, and of course if the killing is unlawful, then you're going to basically presume the existence of malice. Malice isn't a fact that the prosecutor is necessarily proving. They're proving these underlying mental states, and the jury's being told to presume malice from them.
Well, no, the jury in California is never told to presume malice, as they are in Maine.
It's not, they don't use the exact word presume, but they're basically
That's
saying.
pretty important, don't you think?
Well, I think the practical implications of what they're being told is essentially the same thing.
Where do you find it? I've never seen it in the instruction.
What the instruction says is there's two kinds of malice. There's intent to kill, and there's conscious disregard for human life, essentially, expressed versus implied. But it's those underlying facts that the prosecutor's proving.
Right,
and then the
but
jury's
then
holding that equals malice.
Right, but that brings us back to the whole concept of negating malice.
Right.
And that's really the nature of your argument, right? That this was unfair because the jury wasn't instructed on that negating part. So they were just left with the bald facts of intent to kill, and which is malice, express malice, but they just were never told about this underlying ameliorative concept, and therefore there was Chapman error, because it reduced the DA's burden.
Correct, and that's what I was leading to, which is with voluntary manslaughter and murder, it's the same mental state. So the mere fact that there might be evidence of imperfect self-defense presented doesn't tell the jury what role that evidence of imperfect self-defense plays with respect to a finding of malice. For both offenses,
Is it your contention that the jury is unable to connect the dots? Meaning, the defense gets up and puts on a defense that says, well, what the defendant did here was unreasonable, but it was done in a subjective good faith belief that the victim was threatening to the defendant. And the jury is unable to connect the dots between, if the jury credits that evidence, wouldn't they know to connect the dots to know that that negates an intent to kill?
Well, that I think only if that evidence of imperfect self-defense is inconsistent with an intent to kill, but it's not. And as I mentioned, in fact, voluntary manslaughter requires either an intent to kill or conscious disregard for human life. It's baked in as an element of voluntary manslaughter, the intent to kill, essentially. So the jury, it would require the jury, I think, to almost ignore the instructions that they're being given. The instructions say the prosecutor has to prove malice. If the prosecutor's proven intent to kill, then they've established express malice, and that's all they're being told. So you have the defense saying, but yes, I intended to kill him, but I did it because I thought my life was in danger. But the jury's not told that matters. The jury's not told what to do with that. The jury's just told, okay, well, you've just essentially conceded the mental state that the prosecutor has to prove to establish malice, and we have to follow the instructions, even though we feel badly for you, even though we think that maybe murder might be too harsh under these circumstances. We have to follow the instructions. The instructions say intent to kill equals malice. The prosecutor's met its burden of proof.
What is your argument here as to harmlessness, given the specific facts of this case, where you have the defendant shooting somebody in the head multiple times? After the first shot, the victim gets up, shot again, 4 or 5 more times. Doesn't it strain credulity to suggest that there was imperfect self-defense under the circumstances here?
I think it would if the defendant were sort of your quintessential normal defendant. Like, this is a man, if you credit, and if the jury credits his testimony, he had an explanation for why he did each of those acts, each of those fatal acts. He was either partially or somewhat delusional, There's a debate about why, but he had suffered a brain injury. He was claiming that he was, confronting the devil who wouldn't die after the first shot and kept getting back up, and so he would shoot him again. And each one of those shots was preceded by, according to his testimony, a continuing fear he had because the previous acts weren't making him feel safer. They weren't stopping
But
what
that's
he
not
perceived as
all,
a
right?
threat.
So there was also evidence that the defendant was lucid after, and only when this defense was developed did these additional, basically, there was suggestion that he was malingering.
There was a suggestion, but that's a credibility judgment for the jury, and they were never given the opportunity to really make that credibility
Wasn't
judgment.
the argument presented to the jury about the nature of his beliefs in the course of this series of shootings, in connection with the question whether or not the murder was premeditated and deliberate?
I'm sorry. Could you repeat?
Wasn't the argument made by counsel to the jury that it showed that his actions were not premeditated and deliberate because they were induced by the series of beliefs at sort of each stage, each set of shootings?
Well, the principle for the defense, the principal argument was they actually were pushing perfect self-defense.
Right, but wasn't it the argument also made in connection with the question whether or not the murder was premeditated and deliberate? Or am I misremembering the arguments?
You know what? Then I could be misremembering. I don't remember them pushing for. I don't remember the defense's position being that there's no premeditation, deliberation. So second-degree murder would be the option. It was, as my recollection is, they were pushing. The defense counsel was arguing heavily. At least that was the principal argument, that this was a justification defense.
Right, but the arguments nonetheless sound very similar to the arguments you just made to us. I mean, whether imperfect or perfect, I'm reading from the rebuttal, the defense argued that Schuler's testimony showed he was suffering from, quote, severe mental health crisis that caused him to believe the victim was, quote, a physical threat, and that is why he killed. The defense theorized that Schuler's, quote, delusional state of mind had led him to believe that the victim was allied with forces of darkness and react to things that weren't there. These are the arguments that you're making to us as to why the error was not harmless and a retrial is required, but it seems that essentially is the argument that was already made to the jury that they rejected in finding first-degree murder.
But I think what was presented was a perfect self-defense. So his belief in the need to defend himself had to be reasonable for that to work. The problem is there's a gap. So you have on the one hand the jury being told if the defendant intended to kill, that's the equivalent of express malice for purposes of establishing murder. If he felt the need to defend himself and that belief in the need to defend himself was reasonable, it's a justification. But what about the situation where he intends to kill and he does it out of a belief in the need to defend himself, but that belief, because of his delusions, are unreasonable? Jury was never given an option what to do with that.
But that helped me, and I recognize that Elmore and when the instruction is given isn't before us, but the argument you just made sounds a bit like what's prohibited under Elmore. That is, that he was acting in a delusional state, entirely delusional. Again, I realize that question's not directly before us, but it's hard to assess harmlessness without having some ability to assess what the jury would have heard. And when I hear some of the arguments that you're making, it sounds to me like the very things that Elmore said are prohibited from arguing to the jury. So help me think about that a little bit.
Sure. So, but what Elmore said, and this is one of the reasons, this is the principal reason the Court of Appeal, applying Elmore, found that the failure to instruct on imperfect self-defense was an error. Elmore says that imperfect self-defense cannot be based on facts that are entirely delusional. But as long as there is, as the Elmore Court put it, some objective correlate, something connecting the defendant's circumstances to reality, then imperfect self-defense would be required if the evidence supports it. It's a valid claim by the defendant as long as there's that objective correlate. And what the Court of Appeal found, and it was that there was some evidence from which one could conclude that Mr. Schuler's perception of the situation was not entirely delusional, that it was a balance, that, for instance, he had claimed that the victim was attacking him with a knife. Well, there was a knife lying on the dining room table where the shooting occurred.
Nowhere near the victim and with no blood on it.
Nowhere near the victim. Well, nowhere near the victim. It wasn't on the floor. The victim was by the dining room table where he was shot. It was on the table. And yes, it wasn't on the floor. But I would say that if there was blood on it, if it was on the floor, that would be evidence that he was in fact actually attacked by the victim with the knife. That's not the issue, I don't believe, for imperfect self-defense. The issue is whether he believed he was. He believed he was being threatened by the victim. And perhaps unreasonably so. If the knife had been on the floor with blood on it, that would be evidence of perfect self-defense. But that's not what the issue is here. The issue is whether he believed in the need to defend himself and whether it was unreasonable and whether there was some objective correlate for that, and the knife being on the table was one. There's other evidence, though, because there is evidence that, for instance, the body cam footage from the Nevada police officers in Winnemucca when he confronted them, or they had a conversation with him in the hotel. He had interpreted, I think it was one of the officers stepping on a metal plate in the doorway as they were leaving the lobby of the hotel. It made a snapping sound. He interpreted that in his brain as the officers trying to shoot him, that was a gunshot. But there was an objective correlate for that. He didn't just make it up out of thin air. There was a loud popping sound.
But you realize how slippery this becomes, because pretty quickly it becomes, if you believe that a person who, and I think this is the language, to let him to misinterpret actual innocuous events. If Elmore becomes, in your interpretation, if you believe that someone who's not a threat is a threat and are therefore entitled to an imperfect self-defense, I'm having trouble seeing any metes and bounds to the rule. Then it just becomes, I thought that someone who was not trying to hurt me was trying to hurt me, and you can always propound the defense. And so it becomes very difficult for me to understand how you would draw the line between an objective correlate and not. And again, I'm empathetic to you because I realize this isn't directly before us, but it's what we are doing in the harmlessness analysis is in a way trying to envision what should the jury have heard? And the answer is, I'm not sure what the jury should have heard, and that's what I'm struggling with.
I understand. I guess one way to look at it, and I hadn't thought of it, but in response to your question, setting aside Mr. Schuler and his particular professed condition and how he views the world, if you were to have a situation where a defendant who isn't delusional testifies at trial that, yes, I shot him and I intended to kill him, but it was because I was afraid that he was going to harm me, and comes up with some reason for that, whatever that maybe it's I saw the knife, I saw a look in his eye, I felt the need to defend myself, so I shot him. I mean, that's that slippery slope you're talking about, but yet I think that's the situation.
Well, that's the situation we got from Elmore. That's not your fault.
Well,
that's because
but
Elmore
what
is-
I'm saying is I think in that situation an instruction on imperfect self-defense would be required.
Right. So I guess your answer, let me just backtrack a little bit. Your answer on the significance of the jury's premeditation deliberation finding is the same answer to your same as your answer to the question of malice to begin with, which is that nobody really doubts that there could have been evidence, from which the jury can infer these aspects, whether it's intent to kill or premeditation. But that's beside the point, because your point is a person acting in imperfect self-defense could well act with intent and premeditation, but it's the subjective belief that accompanies that is the relevant factor. And here there's plenty of evidence for a fact finder to consider, and that's why this is not harmless.
That's correct.
Do I have it right?
Yes, I don't think intent to kill, willful, deliberate, or premeditated mental states are incompatible with the finding of imperfect self-defense.
But isn't the relationship between them somewhat different? So I understand your argument about the relationship between an imperfect self-defense and a finding of malice, but premeditation and deliberation strikes me as a little bit different in that the nature of self-defense is taking immediate action to protect oneself from immediate mortal peril, right? Which has a little bit the sort of more tense relationship, I think, with the way that we normally describe what premeditation and deliberation means in the context of the homicide law, recognizing, of course, that we've also repeatedly said that there is no sort of minimum time limit that a person has to reflect. But all the same, it does seem a little bit difficult to sort of conceive of the circumstances in which a person could be reacting in the moment to an immediate threat of danger to their person and also simultaneously be premeditating and deliberating an intentional killing.
Perhaps, but I think as you just alluded to, the jury's told that there's no time limit on how long it takes to premeditate and deliberate, that it can happen in a moment, and of course the jury was left with the simply because the jury, I think, found premeditation and deliberation doesn't necessarily lead to the conclusion that they would not have also believed Mr. Schuler when he said that he felt that he was reacting to what he felt was an imminent threat. I don't think, again, I understand where you're coming from. I don't think it's normally the way we think about premeditation and deliberation, nor is it necessarily the typical case.
Do we need to overrule what we said in Manriquez to adopt what you're saying? You remember there we said the jury's first-degree murder verdict, quote, left no doubt the jury would have returned the same verdict had it been instructed regarding imperfect self-defense. Is that case different, or to say what you want us to say, should we overrule Manriquez?
I think if I'm remembering Manriquez correctly, I think it was one line in a statement that wasn't necessary to the outcome of the decision. I think it's dictum. I don't think it's necessarily to be followed. And I as I put in my briefing, if you look at the case on which it's cited as support for that, and I'm going off my recollection, but I believe that case was a felony murder case. So it wasn't really applicable in the situation where you have a malice murder case and you're dealing with an instruction of imperfect self-defense. So I don't believe the legal support for Manriquez's statement in that regard is there.
Counsel, if I'm not mistaken, the first jury hung at the sanity phase. Is that correct?
That is correct.
In terms of the harmless error analysis, what, if anything, should we make of that?
Well, and I believe I briefed this because I found that particularly significant, because that jury, the first jury that hung at the sanity phase, was the same jury that decided guilt. And they were evenly split 6-6 between whether they believed Mr. Schuler was legally insane at the time of the shooting and not. What else is significant is the evidence before them at the sanity phase was essentially the same evidence that was presented to them at the trial. Mr. Schuler didn't retestify. The jury was instructed to consider all the evidence that you heard at the guilt phase, plus whatever additional evidence is being submitted at the sanity phase. And really the only additional evidence that was presented at the sanity phase of any significance was a testimony by Dr. Roof, who had evaluated Mr. Schuler and had diagnosed him with bipolar disorder, but also gave credibility to Mr. Schuler's claim during the guilt phase that the jury could consider at the sanity phase that he, in fact, did kill out of fear that he was in imminent danger. So I think you have a 6-6 split, and of course the issue when applying a prejudice analysis, especially under Chapman, is, is it reasonably possible that this particular jury would have reached a different verdict, in this case on the issue of guilt, if they had been properly instructed? And the prosecution's position was Mr. Schuler was feigning all this. It was all malingering. He's making it all up. Well, you have 6 jurors who actually decided the issue of guilt who didn't think he was feigning it. They thought he really is delusional. They bought his story.
Well, that's not exactly accurate. The jury doesn't have to buy his story to entertain a reasonable doubt. And I have a little concern about focusing only on the first jury. I get the distinction you're making, that it's the same jury that decided guilt, and that's really what we're inquiring into here,
Right.
is whether the guilt finding is legitimate, because we have to inquire whether the jury really understands its obligation to evaluate the law under the statute. I'm a little queasy about trying to read the tea leaves about what a jury that hung may or may not have understood with regard to his sanity. Because as we all know, individual jurors can entertain a doubt for all kinds of reasons. And it just makes me a little nervous when we start trying to go, because that jury hung, done. Now we're having another trial on the sanity phase. So I'm concerned about weighing too heavily on what a jury that didn't reach a verdict actually might have thought.
And I appreciate that. I think if you're going to look at I think that it's the jury finding in the sanity phase is more than just reasonable doubt issue, because the burden was on the defense to establish legal insanity, which means they had to establish legal insanity by preponderance, if I recall. It's more likely than not that he was legally insane at the time of the killing. So it's more than just finding a reasonable doubt. They at least believed it was more likely than not that he actually was suffering from a mental disorder, and as I mentioned,
6 of them did, and 6 of them
right.
didn't.
So it's not even one. It's half the jury believed it. But I understand where you're coming from, and I don't necessarily disagree. I find it particularly relevant. I don't think it's necessarily the only thing you look at and consider. I think if you were to just take the case and separate out the sanity phase entirely and don't even look at it, and if you just look at what happened at the guilt phase, the issue under Chapman, which is what we claim is the standard that controls, is it reasonably possible that if this jury were instructed on imperfect self-defense, that they would have reached a more favorable decision for the defense? And I understand, and I don't disagree, that there are some credibility issues with Mr. Schuler's story. But there's also so many facts that were presented that can't be explained by simple malingering and feigning. I mean, I suppose it's possible, but the extreme creativity that would be required for him to have acted for complete strangers, for his sister, who he was visiting in Nebraska in the days leading up to this, who said that he was talking and hearing voices, talking to people who weren't there. The interaction he had with the Winnemucca police officers that was caught on body cam video and played for the jury, that even had one of the prosecution experts who suspected Mr. Schuler was feigning, still said, but you know what? I'm still concerned, because that video, like that, his feigning doesn't really explain his behavior when he was interacting with those police officers and the way he was interacting with them and the delusional thoughts that he was expressing. And that was the day before the killing. So when you're applying a reasonable possibility standard, yes, there could be some credibility problems with Mr. Schuler's story, and that's up for the jury to resolve. But there's also ample evidence that, in fact, what he said could be true, that he, because of his mental condition, might have actually genuinely been fear of his life, and that's what prompted the shooting. But the jury was never given the option of taking that into consideration in deciding whether this is a murder or not.
So let me ask this question, just because the issue isn't directly before us. I've not been challenged on review here, but the Court of Appeal made a determination that the trial court erred in not giving the imperfect self-defense instruction, which then presupposes that the Court of Appeal found there was sufficient evidence under the standard, substantial evidence, to support the giving of that instruction. How do we think about that determination in the context of reviewing for Chapman error here, particularly in light of what we said in Lopez? Does it inform the harmlessness analysis at all, that there was a basis found by the CA to have given the instruction that was error, even though it's not appealed here?
I'm not sure how to answer that. So I'm not sure.
I'm not either. That's why I'm asking the question.
I mean, maybe it's I'm not sure where you're going, because it brings me back to something. I think your question is making me think about something that a distinction that I tried to draw in the briefing. And I don't know if this answers your question, and if it doesn't, I apologize. But I think one of the tensions and one of the issues that the Court of Appeal had is it's consistently been held by the Supreme Court in California that the failure to instruct on a lesser included offense is a violation of state law only, that Watson applies. And there's been this conflation between the crime of voluntary manslaughter, that's a lesser included offense, and the facts or circumstances that negate malice and reduce a murder to voluntary manslaughter. And I think those are distinct concepts. So the fact that the Court of Appeal found that the instruction was required, I think shows that the Court of Appeal believed there was evidentiary support for it. But where the Court of Appeal, I think, had trouble was where courts have consistently had trouble with this issue in California, which is imperfect self-defense is a kind of or a type of voluntary manslaughter. It's been referred to as being a shorthand description, but voluntary manslaughter is the crime. Voluntary manslaughter is the lesser included offense. Imperfect self-defense isn't the crime. It's the circumstance that negates malice. So I think you can have a situation. Again, I'm not sure if this is helping you at all, but I think you can have a rule or a test where there's a due process requirement that the jury be told, where the evidence supports it, that imperfect self-defense negates malice, while at the same time it just being an issue of state law that the jury be told that the consequence of the prosecutor's failure to meet his burden with respect to imperfect self-defense reduces the crime to voluntary manslaughter. I think those are distinct concepts. And then I think since you have the Court of Appeal saying we think there's evidentiary support for imperfect self-defense, if that's the case, unless it's really weak evidentiary support, which we argue it's not, under Chapman, then it does lead to a conclusion that the failure to instruct, at least on the role that imperfect self-defense plays in negating malice, is a violation of Chapman.
Thank you, Mr. Polsky. We have taken you past your time. I just wanted to let you wrap up if you wanted to briefly.
It. Thank you.
Okay, thank you. We'll next hear from Ms. Poe.
May it please the court. The United States Supreme Court cases have not extended the reach of the Due Process Clause beyond the essential facts or elements of a crime as defined by a state's legislature. There is no reason to do so here. A criminal defendant can attempt to attack the prosecution's case by introducing or relying on facts extrinsic to the essential elements of an offense that the prosecution is obligated to prove. But such defenses have not been understood as implicating due process. Rather, they are a matter of the state's prerogative to permit reduced culpability and, in some circumstances, to eliminate culpability for the offense entirely. Such defenses operate to negate an element of the charged offense that the prosecution has to prove beyond a reasonable doubt.
Well, but it's that last part that is the essence of the case, isn't it? If it's the obligation of the people to prove malice as an element beyond a reasonable doubt, and yet there is evidence that perhaps malice is negated, how do we know that the jury really understood its fact-finding duty to hold the DA to its burden of proof?
Well, we know that because in this case, the jury was completely instructed that the prosecution had to prove all of the elements beyond a reasonable doubt, and the elements of murder were given to the jury. The jury was told.
But that's your friend's argument on the other side. Jury was told, if you find that there's evidence that the defendant intended to kill, we prove malice, we win. And the problem here is that the jury was never told, oh, it's a little more complicated than that. If there's evidence that negates malice, they don't win.
Right.
And isn't that the nub of the question here? The jury was only partially instructed on the essence of the case at issue.
No, because the issue of whether malice is negated by imperfect self-defense doesn't go to the core essential ingredients of the offense of murder in California. Now, imperfect
Well,
self-defense...
the essence of murder in California is you have to prove malice, right?
Right, that's correct. And imperfect self-defense may negate malice, according to this court's jurisprudence, but it is not, in effect, an element of murder, which is the issue here, for due process purposes.
That's a strange argument. The law in this state is that imperfect self-defense negates malice. And so I think it follows that where the jury finds imperfect self-defense, it cannot find malice. But that is I mean, I think your friend on the other side elucidates this point, that is a legal point that the jury would not otherwise have known. In response to my question about whether this was an evidentiary point, I think counsel ably explained that it's a legal point. How would the jury have known the law as to what to do with this evidence if it weren't explained to them by the court?
Well, I understand Your Honor's position that that there was error in not instructing the jury in this case on imperfect self-defense because substantial evidence was presented to support it. There is a distinction between the elements of murder and imperfect self-defense as an extrinsic circumstance that will reduce culpability for the offense.
Well,
and
it's not
the
just,
way
you make it sound like a mitigating factor of some kind. It actually goes to negate the actual element of the offense, and because for federal constitutional purposes you can't convict unless all elements are shown, it goes right to the heart of the case. It's not, you make it sound like it's, I mean, minimizing culpability is a somewhat euphemistic way of putting this.
Well, I think that's what imperfect self-defense does. That is how this state and the court's cases have treated imperfect self-defense. I mean, this really isn't a Mulaney problem. In the Mulaney case, for example, the defendant was tasked with the burden of proof on a heat of passion, which in that case, heat of passion and malice, the judge told the jury repeatedly that those two were exact opposites, that they could not exist. There was either one or the other, and the defendant it was implied that malice existed unless the defendant proved the heat of passion. That's not what's happening here.
But the court in Mulaney went farther than that, right? It wasn't so fact specific. I mean, reading from Mulaney, it says, as a formal matter, the absence of heat of passion is not a fact necessary to constitute a crime of murder in Maine. But then it goes on to say, the rule of Winship is concerned with substance rather than formalism, and because Maine has chosen to distinguish those who kill in the heat of passion from those who kill in the absence of this factor, due process required the state to prove the absence of heat of passion beyond a reasonable doubt. That sounds a lot like this case.
Well, as I was saying, it's true. The heat of passion was the opposite of malice in Mulaney, but in California, it is not the exact opposite, and the jury is never told that imperfect self-defense is the exact opposite. In fact, in this court's cases, like Rios and Bryant, this court has found that imperfect self-defense is present in addition to malice. So it's not that if you have imperfect self-defense, you do not have malice. Malice is always present. It just, as a legal matter, precludes the finding of malice. And also, the United States Supreme Court cases following Mulaney, like Patterson and Engel, those cases really took the holding of Mulaney, which was that the prosecution is tasked with proving beyond a reasonable doubt heat of passion, and retracted and sort of softened that holding.
But Patterson's really different, right? Because New York doesn't define murder as requiring malice, so that's a major distinction.
True, but Patterson was just the start, and the United States Supreme Court there basically said that the prosecution is not tasked with proving affirmative defenses. But if you look at subsequent cases, now we're getting into defenses which maybe the prosecution is burdened with proving beyond a reasonable doubt what would normally be a defense, and the United States Supreme Court has said that in that case, that will not be deemed an element of the offense, which is precisely what my friend on the other side is arguing here. That's the way that he gets imperfect self-defense wrapped into the crime of murder. And the United States Supreme Court has said that just because the prosecution has been tasked with the burden of proving beyond a reasonable doubt a mitigating circumstance or a defense, that does not make that necessarily an element for purposes of due process.
A moment ago, you described the finding of imperfect self-defense as not inherently incompatible with malice. You said that malice is present, but that the finding precludes a finding of malice. Can you unpack that a little bit more? What does that mean?
It means that the way that the court's cases have articulated how imperfect self-defense works is that malice is established, either the intent to kill or conscious disregard for life, and as a legal matter, imperfect self-defense then precludes that malice finding. But it is present. There is an intent to kill, right? There is an intent to, especially in this case, this was an express malice case. There was an intent to kill, but for a specific purpose, at least the argument goes, that it was for self-defense.
But some of our case law describes malice more specifically as not just the intent to kill, but the intent to kill unlawfully, correct?
Correct.
And imperfect self-defense is not that, right? It's an intent to kill, but lawfully. So there does seem to be an incompatibility between the two when described that way.
I think that's true. I think there is some overlap. But the issue then comes down to, is it impermissible overlap in light of the due process clause? And it's the respondent's position that the due process clause is designed to protect a defendant so that the prosecutor is required to prove all of the elements beyond a reasonable doubt for the crime with which that defendant is charged. But that's basically an essential, it's a baseline. And the United States Supreme Court has not gone beyond that, is the point that we're trying to make. The United States Supreme Court has never said the due process clause requires that states hold the defendant to prove a certain defense, or that the prosecution is required to prove an element negating defense. The due process clause is not concerned with the subtle nuances of California law or other state law. They leave that to the states to determine not only the elements of the crimes, but who's allocated the burden and what the defenses may be.
Well, I mean,
Go ahead.
excuse me, I just wanted to say on that point that the due process clause is concerned with what the states are doing, because necessarily what is at issue in all of these cases is how the state decides to order the elements of an offense. And then due process says that these must be proven beyond a reasonable doubt, right? But I don't think the due process clause is read to say, okay, we will adopt you say, you know, malice, and then there's imperfect self-defense, which I still don't quite understand your response to Justice Kruger's question that it somehow screens off the finding of malice. Why isn't that to be understood as how California defines the element of malice? That it's all wrapped up together. Meaning, ordinarily, yes, you were right. Intent to kill, conscious disregard, these are the hallmarks of malice. But, you know, within the ambit of that definition, it is qualified.
It is difficult. Conceptually, imperfect self-defense is relevant to malice, certainly, and that's the conundrum that we're dealing with. But the issue here is looking at it from a federal constitutional perspective. And in doing so, you would look at how the state has treated that doctrine, how the state has treated
let's look at how
imperfect
the state treats that doctrine.
Excuse me?
Let's look at how the state treats that doctrine. So first, the prosecution must prove malice. If they don't prove malice, that's it. However, if they prove malice, because they prove intent to kill, that's where imperfect self-defense comes in, because even if there's intent to kill, as you have said repeatedly, the existence of imperfect self-defense negates that finding of malice. And the essential problem we have here is nobody told the jury about that second step. And if the second step is critical to the DA's burden of proof, it is a due process violation of constitutional dimension.
The imperfect self-defense doctrine is critical to explaining to the jury the level of culpability of the defendant. It's not essential for the crime of murder, which is what we're deciding. Murder is based on malice, and imperfect self-defense negates malice, but what it does, in effect, is it reduces the culpability. Yes, the jury, we would concede that the jury did not know and was not told the instruction on imperfect self-defense and what the legal ramifications would be had they been instructed with voluntary manslaughter. But the question is, what is murder in this state? The question is, what does the due process clause require? And the federal constitution requires that a prosecutor prove beyond a reasonable doubt all the elements as this state has defined it. And this state has defined murder as an unlawful killing with malice. So the due process clause does not require the prosecutor to prove defenses, affirmative defenses, or exigent circumstances. They're not concerned with the subtleties.
How do you meet your burden of proof under Winship on the way to proving malice if there's substantial evidence of imperfect self-defense and you don't negate that? How does the prosecution even meet its burden, which it's required to do under the due process clause?
The prosecutor's already met its burden by proving malice beyond a reasonable doubt. Imperfect self-defense is not so intertwined or the direct opposite, as in Mulaney, as not direct opposite of malice. It is, in our view, an extra circumstance, and that is how this court has treated it for years, which is why it is an error of state law, and Watson applies.
Are you suggesting that it's a justification rather than a fact that goes to negate? We've been using the word negate a lot. Are you suggesting that it doesn't actually negate malice, as we've been saying? It's a sort of external justification for engaging in an intentional killing?
No, legally it precludes a finding of malice. I understand it. It's like a riddle. But we view imperfect self-defense as a justification, as a circumstance, it's similar to a defense. This court has said it's not an affirmative defense, but this court has also said it is just like a defense.
Is your position that if a defendant was convicted of murder when in fact they should have been convicted of voluntary manslaughter because they weren't properly instructed on the component of malice, that wouldn't be a problem of a federal constitutional dimension? There'd be no federal constitutional issue if that were to occur? It
would be state law error. Yeah, the failure to instruct on imperfect self-defense is state law error. That's the position of respondent.
What if it's federal error, then what?
then we would look under Chapman.
And what's your position on the harmlessness
So
analysis?
on the harmlessness in this case, under either standard, whether this court decides that it is a due process violation and Chapman applies, under either standard, even under the tougher standard of Chapman, there is no, the error would be harmless. And the facts that support that are the evidence showed overwhelmingly that the defendant premeditated the murder, and also the jury's finding in looking at all of the evidence was that it was a first-degree murder. And under this court's jurisprudence, particularly in Manriquez, once the jury finds the malice finding and they've gone above that to this upper mental state of premeditation and deliberation, that is incompatible with a finding of voluntary manslaughter.
Why is that? Why is it incompatible? I mean, premeditation under our case law can happen in a matter of seconds. And there is no immediacy requirement for the exercise of self-defense.
Yeah,
right? I don't understand even factually like why that would be the case.
I think that while there is no time constraints and you can premeditate and deliberate instantaneously, I think the notion that someone can calculate a killing and at the same time be in fear and think that they need to immediately
In fact, the two would kind of go together, and I mean, the inference would actually be stronger that these two are compatible than incompatible.
I think a spontaneous fear is much different than a calculated killing. I think the two are not compatible
But
at all.
there's no
and
requirement of spontaneity for imperfect self-defense.
True, but you need to have a reasonable fear that you are in imminent harm, and that immediate
Unreasonable fear.
Unreasonable fear in
Yep.
this case.
Yep.
But that immediate action is needed in order to protect your
Why
life.
immediate? That's not part of the doctrine, is it?
I believe it is. I believe self-defense, unreasonable self-defense,
Okay.
talks about that. And
This-
so even time aside,
But I mean, these terms, immediate, it's very hard to put a time frame on them, right? I mean, you develop a fear. Here it's, we say unreasonable, but, subjectively held. The time it takes to formulate an intent and premeditation upon having that fear can happen in an instant. In fact, if you are afraid subjectively, you might act with greater intention against the person or object that is threatening you in your perception. Wouldn't that actually be the more, in other words, a person wouldn't just spontaneously lash out at the victim. They would, in a calculated way, although it could happen very quickly, target their actions to address the perceived threat.
I would just beg to differ on it. I don't think that at the same time you have a fear of being killed yourself, that you would have premeditation and deliberation, as this court has enunciated that doctrine.
I mean, even taking the facts of this case, it was a sequence of events. This wasn't like a instantaneous thing. I mean, it was a sequence of events which the defendant here, Mr. Schuler, erroneously, but the claim is that he, in good faith, subjectively perceived to be somewhat escalating series of threatening things happening in his environment, leading to a shooting, right? In this kind of, I'm not saying that the view I'm suggesting is correct. I'm just saying, couldn't the jury have thought that his fear was fully compatible with the idea that he premeditated and deliberated before killing?
I don't agree with you. I don't think that they could. I think that particularly in this case, the evidence shows that this was a premeditated, deliberate killing based on the nature of the gunshot wounds, based on the nature of
Assuming all
defendant's
of that.
actions.
Assuming all of that, I'm just wondering why that rules out the other inference that he held an objectively unreasonable but nonetheless subjectively good faith.
Right. Again, I'm probably repeating myself, but I think the two notions are incompatible.
It seems that's what you perhaps would do as a juror, you as an individual or someone, maybe many on the jury, but shouldn't the jurors themselves be the ones to do this type of weighing and balancing of the facts? It seems that you're asking us to do a credibility analysis of the evidence and weighing it ourselves.
No, I guess what I'm trying to say is that the case law, Manriquez, the court has determined that a finding of premeditation and deliberation is incompatible with a lesser mental state of unreasonable self-defense. And that's the point that I'm trying to say. And so that incompatibility, whether they can exist potentially at the same time or not, that incompatibility is another way of looking at the harmless error in this case, and it proves that the error was harmless.
Can I ask, is there something a little bit weird or in tension with the initial concession, which you acknowledged, that there should have been this instruction given, but the predicate to that conclusion is that there is substantial evidence from which a jury could conclude that there was imperfect self-defense. Otherwise, there would have been no need to give the instruction. And if that's the case, how could there not have been a reasonable possibility that the jury would have credited that defense?
When a trial court makes a determination initially on whether to instruct the jury or not on imperfect self-defense, the standard is that a substantial evidence is present so that it's possible for this jury to find that defense. That's a small standard. There's not, in fact, in this case, the evidence that was presented to support the instruction was that there was a knife involved, and the knife was found on the table. And then we have Mr. Schuler's testimony. So the evidence is not great, right?
Well, it is
There was
if you believe
unreasonable
Mr. Schuler. I mean, you can't just say, oh, Mr. Schuler testified to all kinds of things that would point to imperfect self-defense, but let's just look about where the knife is. If the jury credits Mr. Schuler's testimony, there's imperfect self-defense.
True, and I am acknowledging that the testimony would support that finding of imperfect self-defense.
So then there should be an instruction. I'm
trying to draw, well, yes, we concede that there was error and there should have been instruction, but there's a difference between the requirement that a trial court instruct that they find that substantial evidence in the beginning versus whether there is sufficient evidence to find that he acted in imperfect self-defense.
Well, then
And
following
here-
up on I think both Justice Corrigan's questions and the Chief Justice's question, what's your response to your colleague's argument that it's improper for a reviewing court to be making credibility determinations, deciding inferences, that's the role of the jury, that's not the role of the reviewing court?
Right, and I would submit that's true, and that a reviewing court would look to whether the error was harmless beyond a reasonable doubt, and in view of all of the evidence, whether the verdict would have been different had the instruction been given. So yes, there is no credibility determinations being made.
And what about the inferences, though? Both sides have talked about the placement of the knife, et cetera.
Right, I think the placement of the knife goes to the fact that there was no imperfect self-defense, but again, that ultimately, to Your Honor's point, is a determination for the jury. But this court can look at what the jury determined and can look at all the evidence in making their harmless error analysis.
This argument you're making now that the premeditation finding by the jury shows that the error was harmless, that really wasn't made at the Court of Appeal. It certainly wasn't addressed in the Court of Appeal opinion, right? This is a kind of a different argument and a different holding than the Court of Appeal opinion, correct?
As far as my briefing goes, I think I made the argument in the Court of Appeal. Is that what you're saying?
And was it addressed by the court? Did they find harmlessness based on the premeditation finding or not?
I apologize, I don't remember exactly if they...
But the Court of Appeals determination seems somewhat inconsistent in the sense that it found error in the failure to give the imperfect self-defense instruction, admitting that there was substantial evidence to support the giving instruction, but it finds overwhelming evidence in support of its finding that the error was harmless. Those don't seem to be necessarily congruent determinations.
I'm sorry, I'm a little confused on your question.
The question is, the Court of Appeal found that there was substantial evidence to support the giving of the imperfect self-defense instruction, correct?
Correct.
But the Court of Appeal ultimately, in reviewing for harmless error, decided that the evidence was overwhelming, meaning that it would have to have discounted the substantial evidence that supported the giving of the instruction.
Right, or that the remaining evidence that was presented to the jury was so overwhelming that it carried the day.
And in doing so, it made credibility findings on 3 or 4 different occasions. In arriving at that determination, which you've admitted, that's not the proper province in a harmless error analysis for
Right.
right?
So I would agree that to the extent the Court of Appeal made credibility determinations, that would not be proper role for the Court of Appeal. If there's no further questions, we'll submit it on the briefing and the answers today. Thank you very much.
Thank you, Ms. Poe, and thank you, Mr. Polsky, for your arguments here today. We appreciate it, and the matter is submitted. We next invite Justice McConnell for the questioning from the students, or both. No need to ask permission, Justice.
Thank you very much. We're going to take the questions one at a time here at the podium. Thank you very much for taking the time to answer them, and we'll start with, please introduce yourself and ask your question.
Good morning, Your Honors. My name is Aime Mejia. I am a senior at King-Chavez High School. Chief Justice Guerrero, as one of the few Latinas in the legal profession, would you please describe the types of obstacles you face to get where you are today?
Yes, thank you, and welcome to the court. You talk about the number of Latinas, which I wanted to address first, and you're accurate. I'm sure many of you have studied, but the statistics are really troubling. Hispanics and Latinos make up about 36% of the state's population, but only 6% of California's licensed attorneys. So we definitely need to be doing better. In terms of what you describe as obstacles in my life, I think by any objective measure, there are certainly what people would perceive to be obstacles and hardships in my life. I would mention a few that I jotted down. You know, my family came from very limited means financially. They had very little education when I was growing up. My father finished only 5th grade in school. I was raised in a rural agricultural area, the Imperial Valley, that what most people think of are negative themes, high poverty, illiteracy, unemployment rates. And as a first-generation student, I didn't really have anybody to guide me through college, anyone to guide me through law school or to assist in my career path. Nobody that had any connections to sort of lead the way. So I think objectively, yes, obstacles, but I like to look at it from a different perspective, and I consider those to be experiences that have hopefully made me stronger and have shaped who I am. And I'm just really grateful having that background, and I still have friends from the Imperial Valley, and with me here today is one of my best friend's sons who is in the audience here. It's a wonderful community to grow up in. Diego Monroy is with us. I'm sure his father has thoughts on my background too. We've had a lot of great experiences growing up there. It's a really tight-knit community, and so I value that. I value my family's culture, my upbringing, and you know, I didn't have a lot of connections, but I built a lot of relationships that I'm thankful for. Mentors that I've had, including Justice McConnell, my colleagues here on the bench, friends and family who have really kept me grounded. And despite what some would perceive as obstacles, I feel blessed with what I've had.
Thank you.
Another question?
Good morning, Your Honors. My name is Melanie Torres, and I am a junior at King-Chavez. Justice Groban, since your father was a physician, did you ever feel the pull toward the medical field, or was the path of law always a path you wished to walk?
Thank you for your question, and thank you all for being here. I'm so impressed with your engagement and your attention. You've done a better job than sometimes our lawyers do, sitting in the pews waiting, so I'm really impressed. You're right, my father was a doctor and still practices, but I wasn't particularly good at math or science or particularly good with my hands, so I knew that wasn't for me. I was good at talking, and that was about all I was good at, and I just kept doing it, The one thing I learned from my father, though, is he got so much from helping other people and having an impact on other people, and as you wind your way through life and what you want to do, sometimes people will push you towards something because you could make a lot of money, or it'll impress your friends, or you just think you'll be good at it and it would be easy. But as I've progressed in life and talked to people, the people who seem happiest and most excited and enriched by their jobs are people who are doing something where they could impact other people. And so though medicine wasn't for me and I was stuck just with talking and arguing, I did look for something where I could have an impact on the other people's lives, and I'm really glad I did.
Thank you, Your Honor.
Good morning. My name is Karina Lopez, and I go to Monarch School. I'm a sophomore there. And my question is, what goes through your mind when you're making a decision, and what factors do you consider?
And that's for Justice Liu.
Yeah, I apologize.
Corrigan.
Justice
Corrigan.
Corrigan, okay, Justice Corrigan, thank you.
Justice McConnell was trying to trick me.
Or trying to trick Justice Liu.
So that's really a great question, but it's a complicated question, because when we approach these cases, we think about a lot of things. So the first thing we think of course, is given the facts of this case and what we're going to say about the law going forward, we ask ourselves, what's the right and fair result? Of course we think about that. But we have to think about more than that, and we have to think about it in kind of in context. Because here's the thing, judges don't own the law. We are its guardians and its interpreters, but in a democracy, the law reflects the values of the people who consent to be bound by it, and that's all of us. So in our system, while the law belongs to all of us to figure out what the law actually is, one of the things we look at is the will of the people, and that we know from the laws they enact when laws are on the ballot, laws that are passed by their elected representatives, and then kind of essentially we look to the constitutions of the United States and the state of California, because those documents can guide and limit any individual statute that's based kind of on the will of the people at the moment. So we don't just say, if judges ruled the world, here's who would win. We have to consider the body of the law that gives us our authority in the first place. So you know how the system works, right? A trial judge makes a decision, then it can go to the Court of Appeal, and they make a decision, and then maybe it comes to us, where we make the final decision. And there's a saying in the law that the Supreme Court is not last because it's always right, but we're always right because we're last. And what that means at the end of the day is that the law is what we say it is, and with that reality comes a really huge responsibility. It puts the burden on us to be humble when we interpret the law, to be intellectually honest when we do that, and to have the courage to be fair. Because at the end of the day, while we don't own the law and hold it in trust for all of you, we want to make our society as free and just as we can make it. And if we do all of those things and we consider all of these things, then at the end of the day, we've had a pretty good day. And we've exercised our responsibility the way that you entrusted to us. So it's really up to you to see whether or not we're thinking about all the right things. But thanks for your question.
Thank you. Good morning, Your Honors. I'm Amelia Need from Crawford High School, and my question is for Justice Liu. As experienced judges and attorney, what is something you've learned that can't be just looked up in books or online?
Thank you for the question, and I echo my colleagues' appreciation to all the students for being here today, and also the teachers who have put in a lot of time into this, and our colleagues here, the justices and judges here in this district. Thank you so much for putting this together. When I first heard your question, I thought, are there things other than the books and the internet? But of course there are. So, so I thought of two things actually in particular that actually are quite different than books and the internet. The first is, I think, you have to find mentors in your life. You need to have people who know you well and who can be a sounding board and in some ways be kind of an objective observer of who you are and what your potential is, and help you achieve the things that they hear you wanting to do. This can be a parent, it can be a teacher, it can be a church leader, it could be someone, anyone actually a little further along than you who has some experience and can provide some guidance. And I would just urge you to, all of you, to, at whatever stage of life any of you are at, you're never too young or too old to have more mentors and to be open to those kinds of relationships. And the second thing, which echoes some of the things that have already been said, is that you have to listen to yourself. In fact, you know, there are too many books and there's too much on the internet. And what is really needed is oftentimes finding your own passion instead of hearing the cacophony of influences that bear on, you know, telling you what to do. As Justice Groban said, there's lots of different guidance that you'll get throughout your life, and it's worth taking into account. But in the end, you'll be happiest if you find what really interests you and pursue it. I say this with a caution, which is that the lawyering profession has a hard time with this idea. We tend to be one of the more unhappy professions, actually, if you look across professions in terms of satisfaction. Lawyers actually have you know, significant challenges in terms of mental health, substance abuse, these kinds of things, compared to other professions, and it's worth noting. And that suggests that, you know, the path to happiness doesn't necessarily ride through status, money, all the usual things that might motivate people. And so you really have to listen to your inner voice as you develop your interests and go along, both in your education and professional lives.
Thank you.
Good morning, Your Honors. My name is Rueda Abdi. I am a current senior at Crawford High School. I would like to start off by thanking you guys for this wonderful opportunity. My question is for Justice Jenkins. What was the biggest obstacle you faced when changing your career from an NFL football player to pursuing a career in law?
That is a great question, and it's one I've never been asked before in all these years. What was the hardest part of that transition? So I thank you for the question. I thank you all for being here and witnessing your government in action this morning. I think the hardest part of that transition might surprise you, but it was the disappointment from not having fulfilled one of my dreams. And I had two. One was to play in the NFL, and the other one was to become a lawyer. The NFL dream sort of crashed and burned a lot sooner than I expected. I applied to a couple of law schools up in the Northwest and had planned to go to law school part-time as I applied my trade as an NFL player. And I wanted to do that because I thought I could help my community with a platform as an athlete to sort of talk about how one navigates to get to that place and to talk about the importance of setting up scholarships for others. I planned to do all that with that football career. And all of a sudden, having played a preseason game against the 49ers where many people in my San Francisco community came out to watch me play, 4 days later, I was sitting in a law school class that was already 3 weeks into the semester. I was behind in the reading, and I had this deep disappointment and almost grief about this dream that had gone sideways. What that caused me to do, though, was to rely on some of the things I had learned on the way, both academically and athletically, which is resilience, recovering from disappointment, and rededicating yourself, committing yourself, right? And I pulled myself out of that, I'd say even depression. And that was offset by the amazing things I started to learn about law, which is, you tell me an area of interest you have, there's a body of law that applies to it. And so I was learning about that body of law and learning how to strategize with that body of law to help other people. So I think ultimately what was hardest about that transition became the wind beneath my sails and rededicating myself, and it's led me to the most amazing career that I would never have scripted for myself that will end sitting on this court.
Thank you.
Good morning, Your Honors. My name is Hasith Maloro. I'm currently senior at Patrick Henry High School. Justice Kruger, I'm here with Reality Changers, a program that helps students like myself become first-generation college students. How did college shape your career path?
Sure. First of all, thank you for the question, and thank you to all of you for caring about what we do. It's so wonderful to see you out there paying such close attention. And thank you for those of you who've been up here asking questions. I know it is not easy to stand at that lectern and talk in front of this big group of people, and thank you for doing it. When I was in your shoes, when I was in high school, I knew what I wanted to do for my career as an adult was something that helped people. It was something that I had learned from my parents, I had learned from my relatives, a lot of whom who had come to the United States in search of more opportunities for themselves and for me, for their children, and had managed to overcome a lot of obstacles to find places where they were able to help people in the community. They had gone into healthcare, they were teachers, they were ministers. So I grew up with a very strong sense that what I really wanted to do was find the thing that I could do that would help people in my community, whatever my set of strengths, whatever my talents might be, to try to develop them and figure out how best I could use those things to be of service to other people. And for me, college was a really big piece of kind of putting those puzzle pieces together and figuring out what that was. When I went to college, I had expected it to be an intense experience in terms of what was going on in the classroom, and it was. It was a set of new challenges, new kinds of learning, new ways of talking about things that I hadn't seen before. But I realized that a big part of the college experience for me was also what happened outside of the classroom. It was getting to meet students who had come from a lot of different places. It was the chance to see things and do things that I had never and would never have been able to see and do before, and to figure out what that set of where my interests were, where my talents were, where my strengths were, what were the sort of set of things that I had to contribute to the world. My experience in college taught me not only how to open doors, but it showed me that there were doors there to places in this profession in particular that I really hadn't known existed before I went to college. So it was in college that I first learned that I loved to write, and I loved thinking about important issues that affect us as a society. And those two things together, and talking to other students in college who were thinking about going to law school, encouraged me to try that out too, and set me on a path to where I am today, which is a job where I feel like I'm so lucky that every day I get to go to work, do something that I love doing, and to know that what I'm doing is serving other people in the way that I always hoped for out of my career.
Thank you.
Good morning, judges.
Good morning.
My name is Diego Maya, and I attend Rock High School. Judge Kruger, is there any advice you give the students that are entering college?
Sure. So I'll mention a couple of things. One is that, a lot of success in life is, some of it is going to depend on things that are outside of your control. Sometimes it's going to depend on circumstances, on luck, but there's always benefit in getting yourself in a position where those good things can happen to you. So doing the research, figuring out what are the things that you need to do in order to be to satisfy the requirements for admission to college, and sort of making sure that all of those things are in order. And thinking about those things early and often. And I guess the other thing I would say is that college is a time of real transition, because it's the first time when you have a lot of freedom to decide what you're going to study, how you're going to spend your time. You no longer have classes every hour of the day until the afternoon. You get to choose when your classes are, and you have to sort of be self-disciplined enough to get the work done on your own schedule, on your own time. And so thinking now in high school about how do you approach those kinds of challenges? How do you sort of develop the self-discipline and the willingness to take on new challenges? It's sort of like a muscle, right? The more you use it, the more you challenge yourself to sort of to stretch beyond what you know you can do, the easier it becomes to take on new challenges and to tackle new things when you enter a new environment like college.
Thank you.
Thank you very much, Jacqueline.
Good morning, Your Honors. It is so nice to be here. I'm very happy to be here. My name is Jacqueline Danda. I just finished my junior year of high school, and I'm here proudly representing Barrio Logan College Institute. BLCI is a nonprofit community organization located in the heart of Barrio Logan that works with potential first-generation college students and their families beginning in the 3rd grade to prepare them and help them be college ready. They also help make sure they have all the support and the skills they need to make sure they break the cycle of poverty in their family. This question is for Justice Evans. When your job is incredibly difficult and you're very stressed, what aspect of your job makes you want to keep going?
Well, first of all, welcome and thank you for that great question. And I have to say, I've only been the newest member of the court. I've only been on the court since January. And this is probably my favorite oral argument because I got to see your beautiful faces all morning. So thank you all for being here. I know that your schools are proud of you. We're proud of you for being here. I see lots of future lawyers and judges. We promise to keep these seats warm for you. So again, welcome. So what do I do? What do we do when it gets stressful? How do we keep going? Terrific question. I think of 3 words or 3 themes that start with the letter P. And the first one is promise. One of the wonderful, beautiful things about the American legal system is that it promises equal justice to everyone. whether you're rich or poor, no matter what your race or religion, your gender, your sexual orientation. The promise is that we're all entitled to equal justice. So that's one thing. The second P is privilege. As you've heard from my colleagues, it's extraordinarily, we are extraordinarily privileged to be able to sit on the California Supreme Court, to be one of 7 people entrusted by our state to make these decisions and try to make the promise of equal justice a reality is, it's something I cherish and something that I will always, keep me motivated. And I think the final P is perspective. I think it's important, no matter what we do, that we maintain perspective. And I grew up with my grandmother in public housing. She only had an 8th grade education herself. We didn't have any money. I didn't know any lawyers. I didn't know any judges. I think, like my colleague Justice Groban, I like to talk. I like to argue as a child. So I was always interested in the law. But I have perspective about what it means to be stressed or to work hard, because my grandmother worked hard. My ancestors worked hard for very little money, oftentimes under incredibly brutal conditions. Those were hardworking people that labored under stressful conditions. Every day I have the privilege of being in a safe, air-conditioned office, doing this work without any peril of danger. We were well compensated for this work. So that perspective keeps me going. I don't have any business being stressed when I think about the people who really work hard, who really sacrifice to make it possible for me and so many others to be where we are today. So those are my 3 Ps.
Thank you so much.
Thank you.
Thank you very much, Chief and members of the court, and thank you to all of the students for being here. And I'm sure that those of us who are on the Court of Appeal who are here would be happy to stay to answer questions for you if you would like to stay. I know you're probably hungry or ready to move around, but thank you all for being here.
Yeah, I just also wanted to echo that, and thank you all once again to the students who were amazing. You came up there and were obviously so well prepared. We're incredibly proud of you, and I suspect that there may be further opportunities for you to stand at that podium or one like it, at these chairs, members of the court perhaps. But as Justice Liu said, regardless of what you choose to do, you can achieve your dreams. And so we're thankful for the opportunity to be able to meet with you here today, and truly appreciate this. Thank you. And court is in recess now. Thank you.